So the idea of this session is to look at how various aspects of government and the non-profit sector are responding to these changing dynamics of different areas, polycentric forms of finance, shall we say. So I was set myself the goal of thinking about the role of law, and I've done some work on the Vegetation Management Act recently, so I was going to use that as a case study. So, first of all, what does the Vegetation Management Act say or do? It regulates clearing of vegetation on non-urban land. It essentially prohibits the broad-scale clearing of remnant and high-value regrowth vegetation, defined as vegetation that constitutes an endangered, of concern or least concern regional ecosystem that has not been cleared for at least 15 years for agricultural purposes. So for agricultural purposes, you can't do that broad-scale clearing. Okay, now there's a number of exceptions. There's types of clearing that are not covered by the Act. There are types of clearing that's exempt, that would be, for example, clearing for urban purposes of urban land. There's also exemptions for low-risk activities, routine clearing activities. They may be permitted as of right, provided they agree with these accepted development vegetation clearing codes. And then there are some activities a little bit more risky or more larger impact that are classed as accessible development, and they have to be assessed by the State Development and Assessment Authority before they could go ahead. Okay, so you can see that it's actually, while it's simple in agenda, it's actually quite a complex regime to get through all this, like a lot of legal regimes. Then there's category X land, which is land that's been previously cleared and continually used for agricultural purposes, and that's it's classified by the land, but the prohibitions or regulations don't really extend over it. So in Queensland, the Vegetation Management Act is very far-reaching. It covers the regulatory reach extends over approximately 80% of the state's non-urban land. So that's what the figures here are trying to tell you. I think I've done some of the sums correctly here. So you can see that the VMA has effect over 81% of the land. About 19% is category X. The other things that I wanted to draw your attention to are the comparison between the three different types of areas that are governed by the Vegetation Management Act. Look, when we look at the vegetation that's classed as least concern remnant, it's 133 million hectares plus. When we look at what's actually declared as endangered remnant vegetation, it's way down to 902,000 hectares, which I was really quite surprised about. Okay, and there's also, interestingly, the area of native forest containing commercially viable species, again, is in the realm of about 7% there, so it's not huge. So you can see that it's got quite a big reach. It's a big impact piece of legislation for rural Queensland. It wasn't always quite so strict or far-reaching as it is now. For example, in 2013, under the Newman government, there was an Amendment Act which was brought in a few concessions, you could say. It introduced self-assessable development codes for smaller operations that were more generous than the ones we have now. It removed high-value regrowth vegetation on freehold and Indigenous land from the regulatory scheme altogether. And it allowed the clearing of regulation, whether remnant or high-value regrowth, for high-value agricultural purposes, whether on leasehold or freehold land. That was a form of accessible development. So in theory, you should be looking at your environmental impacts when you went through on that. Now, there was evidence that our tree clearing rates almost doubled quite rapidly under that kind of regime. So when the Labour government came back in, there was a move to amend the legislation again. Didn't happen in 2016, but in 2018 it did, and that takes us back to the regime that I described previously. So for all this, toing and throwing, I call it the era of ping pong politics. So that's what that slide's all about. Okay, well, it's exhausting to try and keep track of where this legislation has gone, and fascinating to observe and to tell my students that this is a case of ping pong politics. But the reality is that there's obviously a great deal of contention around this legislation and a great deal of opposition. There are voices on either side, and they've been there for a very long time. In the little, it's not really a full paper, but the notes that I've got to my slides, which I posted to the website, I show you from 2004 a summary of all the concerns that landholders gave to the Productivity Commission, and they're quite telling. So just referring to that 2004 Productivity Commission report, some of the telling comments, this was way back in 2004 now, that were heard before that commission were: all jurisdictions appear to seek to protect native vegetation and biodiversity well beyond that needed to provide net benefits to landholders, because there's always this argument that there's a public good from protecting vegetation on private resources, but there's also a private good in that you'll get some improvement, soil conservation, and lots of things, water retention. We could go into all those details and argue about them as well. Anyway, so another interesting quote was: for landholders as a group, aggregate Australia-wide negative impacts of the regulations will be large, although the distribution of costs among landholders is very uneven. That was interesting. There appear to have been many cases, where the implementation of the regulations has led to a breakdown in landholders' trust in dealing with government. For landholders, this has meant reduced access to advice from government departments, and for governments, a reduction in the ability to use landholder goodwill to promote environmental goals. So I thought this was interesting. This was the Productivity Commission that was identifying these concerns as well. Anyway, that was, some while ago. Bravely, I suppose it's 2 years ago now, was it, Nelson? No, last year, we set out to have a little survey on stakeholders in Queensland. That I should say that Productivity Commission report was about the whole of Australia. And to see if there'd been any movement, to see if things had bedded down, to see if the Vegetation Act was more acceptable now to people. We were a little bit naive, maybe, I don't know. But anyway, we approached Greg, and thank you, Greg, for finding lots of stakeholders for us. And we only surveyed a few people in the end, because the few people that contributed to us through AgForce, which was known to be a little bit, unfavourable to this kind of legislation, were really presented a really diverse range of views. We got in a few others as well. So we were really pleased to get such a wide range of views. You can see we got information from the Greenies, who aren't happy because it's not strict enough, because we still have some degree of tree clearing. We have the people who are not really impacted by it, because mostly all their land has been cleared. So then there's the people who are keeping quiet because, what can you do? We're so, far out of the picture. What can we say? And from the people that we surveyed, and we're obviously quite concerned about it, they're willing to express our opinions. And they were operating more over in this area of operational concerns and a few ideological concerns, which I felt had moved. They'd moved on a bit. There was movement here. They weren't saying, well, it's my property rights affected and stuff so much as sort of, what are we doing and why are we doing this? So to be a little bit more explicit about the feedback we were getting, or to give you a little bit more information, we tried to categorize the feedback into these significant themes, which worked quite well, I think. A lot of the feedback was about simplifying the processes across the board. So these could be admin, operability. Obviously, the continual changes in the law haven't helped to make it clear for anybody, and it is a bit of confusing to get through. You know, I still struggle with it at times. So there's things like that. Let's see. And there were other concerns about the code specifically. So again, operational issues, which I'll go into more at another time. There were things like we need a bit more flexibility here, recognition of regional and on-farm requirements, and but the ones that I wanted to focus on here for the purpose of this workshop were more this feeling that, look, we've got all this land lying here, it's going feral, basically. It's not being tended to, it's not being managed, nobody's really looking after it. You know, we're not allowed to do this, we're not allowed to take it down, but, you know, what are we doing with it? You know, that's the point I'm coming back with. It's not really achieving any environmental goals, it's just thickening up. We can't use it you know, it's becoming less and less productive for us, but it's also, you know, pest species, hoarding feral animals, whatever. So it doesn't really appear to be achieving environmental goals either. And then there was this feeling that we should be seeing the bigger picture here. You know, what role is this legislation taking in all the other stuff that's going on, all the exciting things such as, you know, carbon accounting and this sort of thing. And finally, there was this view put through that, you know, there's been a lot of damage come from 20 years of ping pong politics. You know, and there's a lot of work to be done to repair the relationship now, especially if you want to bring landholders on side and start seeing them as, you know, this new generation of pro-environmental activists and conservationists or whatever. You know, you're starting from a really, really low base. As Ben said, you know, sort of some of those innovators have been drained. Okay, so taking all this on board, here are my two recommendations, and they tie in with a lot of the things that we've talked about today. How am I going for time? Is anybody keeping track of me? Oh, well, I won't be too much longer. I've only got 2 more slides.
12 minutes, Philippa. So you've got 3 more minutes.
Okay, excellent. Firstly, my two big picture recommendations for the VMA would be to clarify the main objective of this Act. Because we know that there is an objective section in the Act. It says we are doing this to promote biodiversity conservation. Well, in farmers' views and looking at the track record, we are not achieving that goal very well. Okay, there's another one saying we're doing this to protect soil conservation, you know, prevent soil erosion. Well, that's all very well, but we know after 20 years that a lot of that relates to how you're cropping the land, what your ground cover is, as we've heard today from Matt. So, and in fact, if you have too many trees, you can start getting erosion, as we heard from Bruce. So we're not really achieving that through the purposes of legislation. The next, you know, down the whole list of many things this Act is attempting to achieve is we want to reduce our carbon emissions, or, you know, as a well, we have done that. We've done that effectively by not pulling down all these trees, but we all know we're nowhere near where we need to be on that journey, and that if we are going to effectively reduce our emissions, that has to be an economy-wide sort of measure. So you can't rely on this one piece of legislation to do all the work for you, even though, you know, to some extent it's doing that. It's a holding station for now. So I say, well, you're not actually achieving any of these goals very well through the legislation. So let's maybe think, what's the key goal that we want to arrive? And once you know what that is, and I would suggest it would be more the biodiversity one, once you know what that is, you know where you've got room to maneuver, where you've got room for flexibility, where you can offer some concessions, where you can do some negotiating, perhaps, for example. So I think we need to do that. And the second one would be to direct some ongoing incentive payments towards people affected by the VMA. Now, I know there was some compensation paid at the time. How effectively is debatable, how much is debatable. But I'm not really talking about a compensation scheme. I'm talking about pragmatics, okay? We now have this vast stock of regulated trees that's thickening up. So, you know, it's going to become less and less productive over time if you just want to graze cattle amongst it. It's not being tended to, it's just being neglected. Instead of using money to always go out and grab more and more land, let's sort of decide what our priorities are for this land and then start putting some money towards that. Now, you might say, well, ERF funds, all these stuff are available there. But of course, if you've already been prevented from pulling any trees or whatever by the law, you're not going to meet those additionality requirements for any of those kind of schemes unless you start thinking of fancy new things to do, and there's not that many out there. So what I would say, well, I have a couple of suggestions. The first one would be, we've got to rethink this requirement for always adding additionality to any type of funding. I know that goes against everything that's in this carbon emissions reduction thing, but we've got to think about thresholds, applying the context sort of arguments that I did this morning. We've got to think, recognize that people come from different places and are at different places. So if we start with a kind of threshold and start payments, scaling up a little bit like the British scheme from that, then we can recognize work that's already been done by those people that have done the right thing all along. So I think that's just a really important point that we need to be reconsidering. And Greg's built that into his outcare system, so I was really pleased to hear more about that. And the second one was, an idea relating to something like, how here in Brisbane we all get waste vouchers, coupons from local government to take, go and take our stuff to the tip. Well, I'm looking for something that's really easy, simple. I won't be much longer, Kate, honestly. This second last point, really easy to administer. It's not going to get you bogged down in transaction costs. It's very flexible. So I'm suggesting something like, well, why wouldn't we have green coupons, for example? Okay, so not for tiny entrances to the tip, but for quite large amounts of money. Okay, you could allocate them to people who, for example, have been badly impacted, or not badly impacted, but have a lot of land taken up under the VMA. So it'd be something like, the equivalent of a rates rebate or something. But this coupon would be, in the trendy way of marketing things these days, would be exchangeable and redeemable. So you could get, and it would only be for environmental purposes. So I'm just saying, in a system like this, you would be directing green credits to people who have a grievance, okay, are already doing their bit by, locking up land in native vegetation. It would be dedicated to environmental purposes. So you're getting those people that are actually quite hard to reach because they're not necessarily innovators or large body corporates or whatever. Okay, you give it to them. If they can use that green credit and redeem it from government, so be it. If they can't, they can exchange it to an NRM or directly to government and get money instead, because they're hard up financially. Maybe they've got other priorities. So anyway, I'm just putting this out there as a big picture idea, and I'm just trying to sort of think up things that target the people that are missing out on other kind of investment schemes. They're not necessarily the innovators. They can't afford big transaction costs. They might have other priorities. So I'm paying attention to those ideas about context, flexibility, need, meeting different people where they're at. Okay. All of that, I know my last slide. Okay, there are reflections here on law. After listening to Matt, I'm not quite so sure that I would really go with this use hard law sparingly. That sounds cruel, but it does seem, I think I would say, use it in conjunction with things that will get people excited about where they're traveling, if you need to use it. Okay, I think the rest probably speak for themselves. So I shall stop speaking.